Thanks for joining again. When an immigration application is refused in Canada, whether it's for a temporary status such as a visitor visa, work permit, or study permit, or for permanent residency, the first step is to understand why. The refusal letter will outline the officer's reasons, and this becomes the foundation for deciding your next move. In some cases, you may have the right to appeal the decision, such as when a spousal sponsorship is refused under the family class. These appeals are heard by the Immigration Appeal Division, which can consider new evidence and reassess the merits of the case. However, most refusals, especially for temporary resident visa, do not have a formal appeal option. In these cases, your remedy is to apply for judicial review in the Federal Court of Canada. A judicial review is not a new hearing and does not allow you to submit fresh evidence. Rather, the court's role is to determine whether the immigration officer's decision was fair, reasonable, and compliant with Canadian law. If the judge finds an error, such as overlooking key evidence, misinterpreting the law, or making findings that are not supported by the record, they can squash the decision and send the matter back to a different officer for reconsideration. Timing is critical in both processes. For refusals made inside Canada, you typically have 15 days to file for judicial review. For refusals made outside of Canada, you usually have 60 days. Missing these deadlines can eliminate your chances to challenge the decision, forcing you to start the application process all over again. This is why it's essential to seek legal advice immediately after receiving a refusal, so you can choose the right strategy, whether that's filing an appeal, pursuing judicial review, or reapplying with a stronger submission. Contact us today if this is you. Thanks for watching, and until next time.